In an article published in the New Yorker on May 30th, 2016, if you can read that, great. If you can't, I apologize. It's not essential. I'm going to put up things on the screen that may or may not be directly related to what I'm saying, so if you get tired of my drone, just read what's on the screen. I won't read it out loud. But let me describe a little bit what this was concerning. Oberlin College is a private liberal arts college known nationally for its diversity and support of counter-dominant ideas. It's a hotbed of radical activism. It became the first white college to admit black students in 1835, and 2 years later it opened its doors to all women. The college made national headlines in late 2015 when a group of black student activists submitted a 14-page petition signed by more than 700 students, making a series of 50, quote, non-negotiable demands, ranging from admissions policies to providing safe spaces on campus for black students. It describes, this piece, if you can't read it, describes Oberlin as an, quote, unethical institution embedded in the white supremacist, patriarchal, capitalist system. Now, this description was difficult to contest. It was probably pretty accurate at a descriptive level, but of course, prescriptively, the demands were difficult, if not impossible, to accede to. They were immediate, and they were calling for wholesale transformation on a schedule of the students' choosing. And I think this petition encapsulates the core challenge of diversity in post-secondary education as a general matter. How should universities respond when their own commitments to diversity are held up as hypocrisy by the very intended beneficiaries? More of the same policies in action are not likely to result in a satisfactory resolution to the discontent on campuses. And this is what leads to the question, are we really ready? I've argued in my academic work that diversity is a statement of social fact, and that it's also normatively ambiguous. Various critical strands of scholarship tie diversity to the equality goal, but even that's normatively ambiguous because equality today, especially in the university setting, is a contested norm. So this is why I ask, are we ready and able to effectively implement diversity, or are we locked in a superficial or thin approach to diversity promotion? For more than 20 years, we've had the language of intersectionality from critical race and feminist theory, which provides us a tool. I don't think it's an end or a goal. I think it's a tool for understanding oppression in various forms and the ways that individuals and members of groups experience the law, experience oppression, disadvantage, discrimination, based on social indicators. Intersectionality complicates identity politics to better align it with identities as they're actually experienced. It gives authority to experience. It is one of the reasons why I think experiential education and diversity can work hand in hand, because with knowledge is power, and for today's students of critical theory, subjective experiences must be given authority. That is a demand that's been put on the table, and I think educators are grappling with how to meet that demand. And this leads to what we have to understand as irreconcilable competing subjectivities, and that is what creates some of the greatest conundrums in resolving conflict and tension in the university setting. In this sense, the dangerous result is that more diversity can actually lead to less diversity if the outcome is a series of siloed echo chambers of like-minded folks creating safe spaces and sticking to themselves only. The silencing of particular perspectives, less interest in difference, less comfort in communications across difference. These are outcomes that are not desirable from a diversity perspective, but yet are potential, if not likely, outcomes of present diversity initiatives. And so this creates, again, comes back to the question, are we really ready? I think at the core we have a crisis in progressive politics. Universities today trade in the language of progressive politics, but they're in fact driven by what we could call a market-friendly multiculturalism. That is a consumerist conception of identity politics in which students are promised and are given the expectation that their individual experience will be reflected in the curriculum. Now that may be correct. There may be a theory of justice that justifies that, but I don't think that's the theory that's operating in the university sector today. And so this sets up conflicts, such as the one introduced at the outset at Oberlin, where you have a liberal, radical institution being accused of being complicit in patriarchy, colonialism, and capitalism, which it is. So it's important to consider this fact, which is that we have a generation of boomer liberals and radicals who currently continue to run universities, witnessing the erosion of the very politics that form the core of their formative years and the core of today's stated university mission. The new left of the 60s is well behind us, and the challenge is that there's a vacuum. And what's going to replace it, what the new progressive politics is going to look like, is very much being debated and fought about today. Left and right is no longer clearly understandable, and there is no consensus on the new progressivism. This all relates back to diversity, because diversity is very much the terrain that is up for grabs. And as long as there is a lack or an unstable consensus around progressive politics, the appropriation of the diversity agenda by profit-driven interests is likely to continue as long as diversity retains its market-friendly appeal. So the difference dilemma, this is what it all comes back to. At its very core, all of these issues come back to the dilemma that's produced by the fact that we love variety, and yet differentiation or difference makes us uncomfortable because it is difficult to categorize difference and not create hierarchy. So the linkages between hierarchy and disadvantage and difference. And the aspiration of equality is to erase hierarchy while celebrating difference. That's really the challenge of equality. The dilemma has not been resolved, and perspectives such as those of the critical race scholars of the 1990s, nearly 25 years later, the words of somebody like Kim Crenshaw still ring true and are still directly relevant to what we're talking about. And I think we heard elements of this through David's and Tom's presentations. What I take from critical race theory is this constant reminder that our foundational assumptions about the law must be questioned, that those foundational assumptions, the canonical assumptions and canonical works, reflect a perspective. Now, what we do about that, and what we draw from the description that Crenshaw offered us, is, I think, very much what's up for debate today. We can accept and we can embed in our teaching styles the idea that at the same time, the law school and perhaps other faculties that teach law, but in particular the law school, is charged with reproducing the cadre of individuals who are going to fulfill the profession and reproduce the notion that it's a noble profession and that the rule of law is a noble aspiration, while at the same time producing people that are able to speak truth about those foundational myths, about the underlying assumptions. So how do we do that? How do we both deal with the self-ascribed view of law as a noble profession and the rule of law as a lofty ideal, and yet confront the reality of the legal profession as an elite profession that reinforces power and stifles social change, while at the same time showing the ways in which lawyers can be drivers of social change. So I think we can agree on these three broad propositions regarding diversity in the law. There's a lot contested, but there's some basic ideas that perhaps I can suggest we've reached a consensus. There are different ways to experience law depending on one's social position and experience. Same goes for legal interpretation. Legal interpretation, there is no single mode of legal interpretation, and as a consequence, there are multiple ways of thinking like a lawyer. Carnegie, which is now 10 years on, reinforced the ideas of what legal education is failing to do. And I think we take that and move forward with that. And then where I turn is to experiential education, which the Carnegie report appeared to embrace. And while the rationale for experiential education has not been directly linked to these diversity paradoxes that I've mentioned, I think the path forward is clear. Experiential education is embraced because it pays more attention to pedagogy, and it goes beyond mere skills training and mere rule repetition, but gets into both structured reflection on students' actual experiences with the law in tandem with substantive education about the law. And there's been a lot of resistance to the idea of experiential education from those who are concerned about the corporate consumer takeover or consumer mindset of legal education, in legal education, and the notion that law societies or regulators are appropriating legal education for the profession's needs. And there's been a rich debate about whether the practice-ready expectation of law graduates is appropriate and what legal education institutions should do about that. I personally think that there is a confluence of interests that enables the law schools and legal educators and legal regulators to come together and find shared goals, shared interests. Practice-ready lawyers can be produced by appropriate experiential education pedagogical approaches. That's not to say that all practical legal training leads to appropriate experiential education. We can come back to that point if I'm expressing that in a confusing manner. But the point about experiential education from a diversity perspective is the opportunity to see law in action and to view it through other perspectives is really, I can't think of a better way to achieve that. You show rather than tell, and I think pedagogically we understand and we agree that is a more effective mode. So let me jump to where we end up. So you hope that at the end of the day, a diversity-minded approach to an experiential education in law will result in lawyers and graduates of legal education programs who have a better understanding of both of how people experience law, but also of the fact of experiential difference. Simply embedding the reality in the mind of graduates that the law impacts people in different ways, perhaps even beyond their own comprehension, but to acknowledge that people's experiences with law are tied to their social position, to their relationship with power, and to their experiences as individuals and as members of particular groups, whether historically disadvantaged or not, is, I think, a primary goal. This kind of lawyer will then have mapped out the boundaries between the personal and the professional role and will be able to show genuine empathy, personal care, professional ethic, allyship, if that's part of their practice, and to find their the appropriate role for being either a reproducer of the administration of justice or a critic of the administration of justice, or that balance between those two roles that the lawyer is called upon to perform. And ultimately, this is what we get. Harvesting student experience and personal learning to create the conditions for students to work through these goals, not by lecturing or telling, because I think if you come with these sorts of goals and use a traditional legal education approach, you run the risk of undermining diversity and undermining student buy-in to the education process. So the goals and the methods really have to be worked out together, and that's the ongoing project for me in trying to better articulate the interrelationship between diversity in action through experiential education and the theoretical assumptions and goals underlying it.